Gentlemen, before I take the second motion by the third respondent, this application filed by the petitioners challenging the reply of the third respondent, to which his second motion relates. This motion by the petitioners should come and be taken first before the second motion by the third respondent. So I'll deal with the ruling in respect of the motion by the petitioners, which was filed on the 13th of May 2019, challenging the competence of the third respondent's reply to the petition. This is the leading ruling. The motion seeks the following reliefs. A, an order striking out the entire reply of the third respondent to the petition for being grossly incompetent. Or in the alternative, B, an order striking out paragraphs 1, 2, 3, 4, 5, and 6 of the third respondent's reply to the petition for being extraneous to the petition and thus incompetent. There are 4 grounds upon which the prayers are premised, and it's supported by an affidavit deposed to by Jedidia Daudu. The third respondent, as it was to be expected, filed a counter affidavit and a written address on the 20th of May 2019 to oppose the application. The learned senior counsel for the petitioners, in his written address, submitted 4 issues which he said called for determination in this motion. And I will read them. 1, whether the reply of the third respondent to the petition is competent in the absence of the National Identity Number, NIN, of counsel who signed the reply shown or reflected on the reply as mandatorily required by the provisions of the mandatory use of National Identification Number Regulations 2017. 2, whether the challenge of the qualification of the first petitioner to contest the presidential election raised in the reply of the third respondent to the petition, which was filed outside the 21 days stipulated for the filing of an election petition, is not stated bare. 3, whether the qualification of the first petitioner to contest the presidential election of February 23rd, 2019 can properly be raised in the third respondent's reply to the petition. 4, whether the contention of the third respondent that the first petitioner is not qualified to contest the presidential election on 23rd of February 2019, not having been supported by any relief, is rendered incompetent for being hypothetical, academic, and speculative. And he argued those issues. For the third respondent, 2 issues are raised in the written address, and they are as follows. Whether the petitioner's instant application as constituted, challenging the competence of the third respondent's reply to the petition is competent and proper before the Honorable Court. And 2, having regard to the peculiar circumstances of this petition, whether the petitioner's motion seeking to strike out the third respondent's reply to the petition or the instant application is meritorious and grantable. And learned senior counsel went on to argue their issues. And after a consideration of the arguments by the learned senior counsel, I went on to determine the merit of the application. And I started with saying, by a mere glance or visual observation of the signature on the motion paper and the signature on the written address accompanying the motion paper shows similarity in the two signatures, indication the motion paper and written address were signed by the same person. And I find that the motion and the written address were signed by one and the same person. And I find that under Section 101(1) of the Evidence Act as amended, and the authority of FCMB against CP Tech Construction Company Limited, a case decided in 2015, and citation set out, empowered this court to compare signatures and form an opinion on them. The written address has the name tick. The written address has the tick name of counsel that signed it, and his MBA seal identified as Jude Daniel Odi Esquire, showing both the motion paper and the written address were signed by an identifiable legal practitioner, Jude Odi Esquire, whose name can be traced to the role of legal practitioners. Both processes are therefore competent in this petition. The application is titled Motion on Notice, and it has prayers in form of reliefs stated on page 1 thereof, and the grounds upon which the application is based is also contained on page 2 thereof. It is therefore not a notice of preliminary objection. Paragraph 47 of the first schedule to the Electoral Act entitles any of the parties in an election petition to file an application by way of formation or notice in these words, and I set them out. The petitioners being parties in this petition are therefore entitled to file the present motion or notice. Paragraph 47(2) of the first schedule to the Electoral Act uses the permissive word may in respect of filing an affidavit in support of the motion. Consequently, unless an affidavit is necessary for the application by way of a motion or notice, the parties or party filing the motion need not file an affidavit in support of a motion. The third respondent cannot therefore be right in the submission that every motion must be supported or must have a valid affidavit in support of such motion before the motion will be competent. In my opinion, paragraph 3 of the affidavit in support of the application contains statement of facts not extraneous to the matter by way of objection, prayer, or legal argument or conclusion, and does not offend it does not offend Section 1152 of the Evidence Act. The objection to the said paragraphs of the affidavit in support of the motion is accordingly untenable and is hereby rejected. Now, Regulation 11U made pursuant to NIC Act provides thus: in accordance with the provisions of Section 27(1) of the Act, the use of the National Identification Number shall be mandatory for the following additional transactions: filing and registration of criminal and civil actions in courts and other arbitration processes. The Supreme Court, like we pointed out in an area ruling this morning, in the case of Marafa, APC and Marafa, cited by the third respondent, in relation to Section 27 of the NIC Act and regulations made thereon, held thus, and I repeat again, Section 27 of the National Identity Management Commission Act 2007 and its regulations are not part of the rules of this court and cannot therefore apply to the proceedings filed in this court. Clearly, I find no merit in the preliminary objection. Accordingly, same is hereby overruled. End of quote. The first leg of the relief supra in the motion paper seeking to strike out the third respondent reply to the petition for violating the NMI Act or failure to insert the national identification number of the third respondent senior counsel that signed it is therefore untenable and is hereby rejected. Paragraphs 1, 2, 3, 4, 5, and 6 of the third respondent's reply of the petition read thus, and I set them out. Then paragraph 12(2) of the first schedule to the Act provides, and I quote, where the respondent in an election petition complaining of undue return and claiming the seat or office for a petitioner or petitioner intends to prove that the claim is incorrect or false, the respondent in his reply shall set out the facts or figures clearly and distinctly disproving the claim of the petitioner, end of quote. What this paragraph provides for is the requirement of pleading, joining the respondent to set out, and joining the respondent to set out facts and figures frontally, distinctly, and clearly disproving the claim of the petitioners upon which the petitioners are challenging the return of the second respondent as the winner of the election. The facts and figures sought to be disproved by the reply are therefore those that are tied to the averments in the petition on why the second respondent should not have been returned as elected. It is difficult to appreciate how the qualification of the first petitioner to contest the election would add value or impact to the traverse of the third respondent in the third respondent reply against the petitioner's grounds with respect to the return of the second respondent, who was sponsored by the third respondent in the said election, under challenge in the present election petition. Instructively, it was held by this court in the case of Idris and AMPP 2018 and 2008, citation of which is set out. Sanusi again, JCA, as he then was, has stated, this time I quote him briefly, it goes without saying, therefore, that if the appellant wanted to use the ground of qualification of the second petitioner for whatever reason, it had to file a cross petition. Before the motion would be competent. In my opinion, paragraph 3 of the affidavit in support of the application contains statement of facts not extraneous to the matter by way of objection, prayer, or legal argument or conclusion, and does not offend it does not offend section 1152 of the Evidence Act. The objection to the said paragraphs of the affidavit in support of the motion is accordingly untenable and is hereby rejected. Now, Regulation 11U made pursuant to NIC Act provides thus. In accordance with the provisions of Section 27(1) of the Act, the use of the national identification number shall be mandatory for the following additional transactions. U, filing and registration of criminal and civil actions in courts and other arbitration processes. The Supreme Court, like we pointed out in an area ruling this morning, in the case of Marafa, APC and Marafa, cited by the third respondent, in relation to Section 27 of the NIC Act and regulations made thereon, held thus, and I repeat again, Section 27 of the National Identity Management Commission Act 2007 and its regulations are not part of the rules of this court and cannot therefore apply to the proceedings filed in this court. Clearly, I find no merit in the preliminary objection. Accordingly, same is hereby overruled. Not to use such alleged non-qualification of the second petitioner in the motion defense of paper seeking to strike out 138(1)(a) of the Electoral Act also state an election may be questioned on the ground that the person whose election is questioned was at the time not qualified to contest the election. The person whose election is complained of is by Section 137(2) of the Electoral Act referred to as the respondent. while Section 239(1) confers on this court the jurisdiction to determine whether the person has been duly and validly elected to the office of the president or vice president, thus limiting and circumscribing the jurisdiction of the court to the issue whether the person whose election is questioned was validly elected. It does not extend to determination of whether any of the petitioners who is challenging the election or return of the respondent was qualified to contest the election. The fact that the petitioner pleaded that the first petitioner had the right to be voted for and return in the election to the office of the President of the Federal Republic of Nigeria would not enlarge the jurisdiction of this court under Section 239 of the Constitution, which, along with Section 137(2) and 138(1)(a) of the Electoral Act, as parties cannot and do not, even by consent or acquiescence, confer jurisdiction on the court. I made reference to some cases. It is accordingly my view that the issue of qualification or disqualification of the first petitioner to contest the election is only a ground for challenging the election of the person returned, the second respondent hearing, and not a defense or a reply to the petition. In the result, I find substance in the second and alternative leg of the motion paper, impugning paragraphs 1, 2, 3, 4, 5, and 6 of the petition, which is hereby granted, and the said paragraphs of the third respondent reply to the petition, challenging the qualification of the first petitioner to have contested the election in question, are accordingly hereby struck out. I also made reference to the case of Atiku and Fashionable Supra. In conclusion, this motion succeeds only in respect of the second arm of the relief sought, which is hereby granted, while the first arm of the relief, which is not made out, is hereby refused and it is dismissed. My honored brother to my immediate right will pronounce his own decision in respect of this motion.
I agree with the ruling just delivered on this motion.
My honored brother to my immediate left would also say his decision in respect of this motion.
I also agree.
My honored brother to my extreme right will now say his own position in respect of this motion.
I agree.
My honored brother to my extreme left will also pronounce his own decision in respect of this motion.
I agree.
Gentlemen, I now deal with the second motion filed by the third respondent on the 14th of May, 2019. And the motion primarily prays for the following reliefs or orders. An order of this Honorable Court striking out Part A of the petitioner's reply to the third respondent's reply to the petition, dated and filed 18th of April 2019, for being incompetent and in violation of the mandatory provisions of the Electoral Act 2010 as amended. It also seeks an order of this Honorable Court striking out paragraphs 1 to 21 of Part B of the petitioner reply and or entire petitioner reply to the third respondent's reply to the petition, dated and filed on the 18th of April 2019, for being in gross violation of the mandatory provisions of the Electoral Act 2010. Also seeks an order of this Honorable Court striking out all the witnesses' statement of oath filed together with the petitioner reply to the third respondent's reply to the petition, for being irregular and in flagrant compliance with flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2010 as amended. And the prayers are premised on 15 grounds which are set out. And the motion is supported by a 26 paragraph affidavit, as well as a written address. The petitioners oppose the application and file a 6 paragraph counter affidavit, to which is also accompanied a written address. In the written address, the third respondent submitted these issues for consideration, 2 of them. And they are whether this is not a proper application, to be heard and determined by this honorable tribunal before or outside during the pre-hearing session. And 2, whether the petitioner replied to the third respondent replied to the petition dated and filed on the 18th of April 2019 and or the offensive paragraphs therein, together with all the accompanying statements on oath and the purported preliminary objections embedded therein are not incompetent and liable to be struck out in the instances of this petition. On their part, Land Senior Counsel formulated also a single issue, which is whether the said averments reply and the accompanying written statement offend the provisions of section or paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act 2010 as amended and are liable to be struck out. We went on to consider first the objection by the applicant to the motion. And then I went on to discuss and determine the sole motion in the motion. After a consideration of all the submissions on the objection as well as the merit of the application and the issue raised, I went on to say that the real issue in controversy in this application is whether the reply to the third respondent reply to the petition dated and filed on the 16th of April violates paragraph 16(1)(a) and (b) of the first schedule to the Electoral Act, which provides thus, and I set it out. A petitioner, by the above provision, in reply to the respondent's reply to the petition, shall not include or bring in new facts which are capable of amending or adding to the contents of the petition. The petitioner's reply must not introduce any of the requirements of paragraph 4b of the said schedule. The petitioner is also prohibited by paragraph 6 are liable to be struck out. This is because the Electoral Act 2010 does not permit a petitioner to hide under the guise of filing a reply to a respondent's reply to the petition to set up a different case from what he already had relied upon in the petition. And I made reference to some cases in respect of this. I have calmly scrutinized the petitioner reply to the third respondent's reply to the petition, particularly Part A, dealing with the preliminary objection. And I'm of the view that paragraphs 1 to Roman 1 to Roman 18 thereof do not offend paragraphs 16A and B of the first schedule to the Electoral Act, as all the paragraphs contained in the third respondent's reply to the petition, paragraph A, notice of preliminary objection, raise new issues of facts in defense of the petition, which the petitioners have not dealt with in their petition. In respect of Part B of the reply to the third respondent's reply, the petitioners raise objections to paragraph 1, 2, 3, 4, 5, and 6 of the third respondent reply, contending that the matters relating to the qualification of the first respondent ought to be by way of a formal petition within 21 days after the date of declaration of the result, and that the said paragraphs touching on qualification cannot be done by a reply. This issue has been resolved in the ruling just delivered in the petitioner's motion of 13th of May 2019, challenging the said paragraphs of the third respondent's reply to the petition, dealing with the petitioner's qualification to contest the election in question. For reasons set out in the said ruling, the said paragraphs of the third respondent's reply to the petition on the qualification of the first petitioner to contest the election remain and are hereby struck out once again. The petitioners, under the objection in Part B of the petitioner reply, submitted that the third respondent reply is incompetent because the learned senior counsel who signed the reply has no name number shown or reflected on the reply in breach of the NIMC Act. I am of the view, as held by the Supreme Court, that the same regulations do not apply to proceedings filed in this court. And this issue has been decided in a ruling by this court on the 24th of June 2019 in the second respondent's motion to amend his reply to the petition, and in the ruling just delivered on the motion filed on the 14th of May 2019 by the second respondent on the authority of the case of APC and Senator Kabir Marafa and others. Now, the filing and signing of court processes are governed by Section 2, 1, and 24 of the Legal Practitioners Act. The objection to the petitioner's prayer 1, 2, 3, 4, and 5 of Part B of the third respondent's petition is therefore lacking a merit and it fails. In respect of paragraph 5 to 21 of the petitioner's reply to the third respondent's reply under Part B, pages 5 to 11 of the reply, it is necessary to compare the paragraphs with paragraph 16(1)(a) of the first schedule to the Act in order to determine if, in fact, they contravene the said paragraph of the first schedule. In my view, it is my view that paragraph 5, 6, 7, 8, 9, and 11 of the said paragraph of this petitioner's reply to the third respondent's reply, Part B, are within the contemplation of paragraph 16(1)(a) of the first Electoral Act, as they were necessitated by new issues of fact raised by the third respondent in the reply to the petition. However, a close perusal of paragraphs 10, 12, 13, 14, 16, 17, 18, 19, 20, and 21 of the reply, they are clearly outside the precinct and contemplation of paragraph 16(a), 1A and B of the first schedule to the Act. But they are in gross violation of the said paragraph of the first schedule to the Act. The paragraphs 10, 12, 13, 14, 15, 16, 17, 18, 20 to 21 of the petitioner reply tantamount to bringing in new issues, new grounds, and prayers tending to amend or add to the contents of the petition. These paragraphs for violation of paragraph 16(1)(a) and B of the first schedule to the Electoral Act are liable to be and are hereby struck out. At the same time, all the paragraphs of the witness statement on oath filed together with the petitioner's reply to the third respondent's reply to the petition are consequently struck out insofar as they touch on the paragraphs which were struck out in Part B, which have now been struck out for being in contravention and breach of paragraph 16, subparagraph 1, A and B of the first schedule thereof. My learned brother to my immediate right will pronounce his decision in respect of this motion.
I agree.
My learned brother to my immediate left will say his decision in respect of this motion.
I agree.
My learned brother to my extreme right will now say his decision in respect of this motion.
I agree.
And my learned brother to my extreme left will also pronounce his own decision in respect of this motion.
I agree.
Gentlemen, at this juncture, we will take a very short break to refresh and then come back. The break will be very short. Where is this? Take this one.
It has taken about 3 hours. The substantive matter is now to be determined after the resumption of the justices. We are taking a little break from the presidential election petition court, but we are still with them because the studio is still here. And our guests have still been very patient, although they have been engaged by the presentation, by the delivery of the various rulings. We have here in Abuja, Dr. Hassan Liman, Senior Advocate of Nigeria, of course, a legal practitioner, Abuja-based. You're again for remaining with us.
Thank you very much.
And also with us is Honorable Ahmed Sajo, sorry, I turned the O before the A. Sajo, the former Commissioner for Information in Adamawa State. Thank you for remaining with us.
Thank you very much.
And in the Kaduna studio, we still have Professor Kabir Mato. We'll join him later. He will come to us later. Let's evaluate what the import of the time we have spent with the court. And let me start first with the opinion of Dr. Hassan Liman. What do you think of the time we have spent in the last 3 hours? How valuable, how judicially valuable has that been?
The time spent is so valuable in the sense that in the last 3 hours, the lordships of the Court of Appeal, sitting at the Presidential Election Tribunal, arrived at far-reaching decisions, especially in the preliminary objections that were filed by the respondents and the petitioners. Issues were decided, and then it brings to fore the advantage of the fourth alteration to the Constitution, wherever Section 285 of the Constitution is amended by adding of that all preliminary matters, if they are argued before a tribunal, rulings are deferred to be delivered along with the judgment. It has saved precious judicial time, and then it has put an end to the multiplicity of interlocutory appeals that will move all the way to the Supreme Court while the substantive matter is still pending at the tribunal.
Is it possible? Is it possible that the substantive matter will go whichever way it has gone, and somebody will go on appeal over these preliminary matters that have been ruled on, if the substantive matter does not go his way? Is it possible?
Well, it's a legal matter, and let me confess that I'm not a legal person.
Okay.
But I tell you that whatever happens, this is a very welcome innovation. This is a very welcome correction to the old system,
yes,
where legal practitioners use the opportunities provided by this interlocutory
objections
to delay a case,
yes,
ad infinitum in some cases.
Yes.
This is a very good one, and it creates, proper traction of the issues. But one other thing I have noticed, which I am very, very pleased with, which tells me that there was some thorough job done by the judges, was that there was no objection at any point in time when the lead judge makes his pronouncement. He will ask his learned brother judges, and none of them will object, which means there was a level of thoroughness, and there is also a level of unanimity in the decisions that are taken. And I believe that anybody who is willing to appeal on some of those issues can appeal, but the absence of objection by the other judges, the thoroughness that have been done, had actually reduced the grounds, for appeal to the barest minimum.
Okay, Dr. Hassan, I'll try not to lose track of as many rulings has been given. But let's start from the first one. Is it possible for, like I just asked, is it possible for now that we know the ruling, we can mention names? Is it possible for APC or indeed, because it affects INEC. INEC was the one that raised that objection about the qualification of the petitioner's lawyer to practice law in Nigeria. Let's start from that. Is it possible for them to go on appeal over that?
Well, you see, it is a finding or a final decision by the Presidential Tribunal. they have the right, if they are not satisfied with the ruling just delivered by their lordship, at the end of the final judgment, if they are not satisfied, they can file an appeal as one of the grounds that they may want to appeal against. But it all depends on what will be the outcome of the final decision. Because if you are not satisfied, you have the right to appeal. Okay. If you are satisfied, you don't file an appeal. It all depends on what will be the outcome of the final decision.
Was it that they wanted the judges or justices to do the research for them? Were the papers, the qualification of Dr. Levy not available for them to know? Why was it the justices that did the finding of whether he was qualified to practice law in Nigeria or not?
You see, the Legal Practitioners Act has defined who is a legal practitioner according to the meaning of that. One who is called to the Nigerian bar and has a role in the Supreme Court to practice law as a solicitor and advocate of the Supreme Court of Nigeria. If you go into the role of lawyers in Nigeria, the evidence is there to find whether Dr. Levy has been really called to the Nigerian bar or has a role or has been a role to practice law in Nigeria. So it all depends on what was presented to their lordships by those that are opposing his right to practice law and sign the petition on behalf of the petitioner. If this evidence is available to them, and in my humble opinion, with all due respect, the objection was an unnecessary objection that ought not to have been brought.
I think so.
Yes, good. You can combine your opinion of this first one with the second one, which was that the petitioners did not join the vice president in their petition, and so the petition should be thrown away. That was another objection from the respondents. What do you think about that?
No, I think the president and the vice president.
It's a joint ticket.
A joint ticket, and of course, let's put it this way: there is definitely a senior partner.
Yes.
And if you involve the senior partner, it presupposes that every other partner within the setup is part of it. The banner is handed over usually to the presidential candidate, not to the vice presidential candidate. The vice presidential candidate is part of the presidential candidate. Look at it even in governance. The president of the federation is the one that governs the country. The personal aides of the vice president are not called special assistant to the vice president. They are special assistant to the president, posted to the office of the vice president. So it's the system that recognizes the fact that the presidency is one. And if the presidency is one, I think the candidature too should be one. So, but sometimes you see arguments, legal arguments, like I said. One of the things that bothers me too much about the legal practice in this country is that we pay more attention to legal technicalities than justice itself. And we're waiting. It's the substantive issue that will determine what we're all talking about here. If the substantive issue is determined whichever way, I'm telling you that my brother here, the learned said, his constituency, the legal profession, your own constituency too, will come together and use even this tiny technical matter to go on appeal. But the truth about it is that I think the presidency or the candidature of the president and the candidature of the governor being joint is one one ticket, and but there should have been no argument about whether the vice president is joined or not joined.
Then we begin to go to areas where, talking about technicalities, they are indeed actually technical. We don't have the motion papers with us, so when they begin to talk about striking out relief 1, relief 2, relief 3, some of us are lost because since we don't have the motion papers, we don't know the reliefs that are being sought. What did you understand by some of the motions that sought for the striking out of some reliefs?
You see, so many applications were presented before the tribunal by the 3 sets of respondents, and then equally by the petitioners. In some of the applications, they were saying some grounds of the petition or some paragraphs of the petition are incompetent or are vague or are nebulous and ought not to have been filed at all. In some of the cases, the tribunal agreed with the respondent and then struck out some of the paragraphs, while in some instances, the tribunal dismissed and said that some of the paragraphs were competent. And then if you look at it, there are other issues that also crop in, like whether or not the issue of qualification of the president is a pre or a post-election matter. The tribunal, in its wisdom, in its final decision, held that the issue of challenging of qualification is both a pre and a post-election matter under section 31 and 138 of the Electoral Act. So if you can take it under section 31 before the conduct of the election, on the publication of the particulars of the presidential candidate, then whoever is not satisfied with what has been displayed in the constituency, then he can approach the Federal High Court to challenge that this man who is standing election is not qualified. But if he is unable to do that, he still has the right, as decided by the Presidential Tribunal and has already decided by several decisions of the Apex Court of the land, that he can present it as a post-election matter.
And the latest one was the one in July by the Supreme Court.
So that one is one area with the greatest respect and also sensibility that we should bother and label about, because the Apex Court has spoken about it. But it has been presented. The Presidential Tribunal must still give a decision, and they have given their decision. The second aspect is, the second area of challenge is whether or not a respondent can challenge the qualification of a petitioner. In this case,
since the petitioner is not the one in the contest.
In this case, it is very interesting. When Atiku Abubakar challenged the qualification of President Muhammad Buhari that is not qualified, the lawyers on the other side, the third respondent in particular, that is the APC, through their counsel filed and in their reply raised the question as to whether or not Atiku Abubakar, candidate of the PDP, is also qualified, that he is not qualified.
A counter motion.
In the counter. So, but the Electoral Act is so interesting, it's so beautiful. And then the Constitution, it has set out who are those that can present a petition. What are the grounds for election petition? A political party or a candidate in an election can present a petition. And respondents are to defend it. Here, the candidate, the political party, and the electoral board.
Exactly.
So, as decided by their lordships now, there is nowhere with us as a responsibility in the electoral law, especially the 2010 Electoral Act as amended, and the Constitution of the Federal Republic of Nigeria, that has given a respondent the right to challenge the qualification of a petitioner. But it has given that right
to the petitioner
to say that the person whose election is in question, that is a respondent, his qualification can be challenged. The law that he is not qualified to stand that election.
And honestly, Learned Silk, I like the way the learned justices, their lordships presented it.
Yes,
it's like the respondent was also presenting a petition against the petitioner.
Yes, but if you look at it very critically, before the 2010 Electoral Act, in 2003, 2006 Electoral Acts, which were all finally repealed and amended and replaced by 2010 Electoral Act as amended, which is the subsisting legislation. There used to be what we call a cross petition.
Okay.
But with the amendment in 2010, what we have in the 2010 Electoral Act is what we call objection to votes.
Okay.
You cannot set up a cross petition as a respondent. What you can only do is that if you are saying, I have not won the majority of lawful votes as the winner of the election, in the areas that you have won, those areas that you are won, petitioner, you have not won them, and then you are urging the court in this when you missing the petition, also take away the votes, additional votes that he has won, because they are not valid votes for also the petitioner. But nowhere, with all sense of responsibility, that has it been provided by the Electoral Act that a respondent can challenge the qualification, and their lordships have spoken, given their decisions.
And is that right decision?
Are there, from what you know that are before the court, are there strands of this qualification in the substantive matter, or the substantive matter is wholly now made on the number of votes that the petitioners are contesting?
No, what we are about to see now is decision on the main grounds of the petition. 2 or 3 grounds are there. Number one, Atiku is challenging the election of President Muhammad Buhari on the ground that he is not qualified to stand the election. That has been decided. Number 2, that President Muhammad Buhari, according to Atiku Abubakar, has not won the election by the majority of lawful votes. These are essentially what their lordships will come to decide. Whether Muhammad Buhari, President Buhari, is qualified or was qualified at the time of the election to stand the election. And number 2, whether he has won the election with the majority of lawful votes as declared by the electoral body. That's what we are waiting to see the lordship decide.
Honorable Sergio, we have seen the disposition of people, everyone in the courtroom. At the beginning of this program, we talked about the development of our democracy. Have we seen signs from the issues that have been canvassed so far? Have we seen signs that not only politicians are supposed to learn from the development of our policy, our lawyers too, learning from the development of our democracy in terms of previous rulings, previous judgments given by courts?
No, I think the most interesting thing that is playing out is, and I like it, when you take issues that were hitherto, hidden to people, and you bring them out to the public